Order, please read your report. Can I have a copy?
Right, Honorable Speaker, this minority report is presented pursuant to Rule 215 of the Rules of Procedure of this Parliament. It descends from the majority report of the Committee on Legal and Parliamentary Affairs on the Political Parties and Organizations Amendment Bill 2025, by the Honorable Nakut Faith Loru, District Woman Representative of Napak District, and seconded by Honorable Mutembuli Yusuf of Bunyole East and the Honorable Afidra Ronald Olema of Tororo County. Dissent. The bill is unconstitutional. That is the first point of dissent, Madam Speaker and members. The bill is unconstitutional. The minority observed that all political parties and organizations that the Political Parties and Organizations Amendment Bill 2025 contravenes the provision of Article 93 of the Constitution of the Republic of Uganda and Rule 130.
Is a procedure matter.
Thank you, Right Honorable Speaker. Madam Speaker, this is a House of Record. I just had the Honorable Dur mention a honorable member by the names of Afidra Ronald and is locating him in a constituency in Tororo. The Honorable Afidra I know of is from Madio Koro. Wouldn't it be procedure right, Madam Speaker, that this record is put correct for posterity?
But was it also necessary to call a member of parliament? Let's present the minority report.
Speaker, part of the documents that have been submitted includes a memorandum submitted by the movers of the bill. They appeared before the committee, and in the opening paragraph, which I can read to you, signed by Honorable Yusuf Mutembuli in the presence of the Honorable Afidra, paragraph 2 says...
Honorable, what is saying, correction of the constituency, not Tororo County. Is Angora, Honorable Angora. You mean they have taken over your constituency?
Right, for the Honorable is not a member representing any constituency in Tororo and Tororo County, to be specific. We have Tororo County North, represented by Honorable Geoffrey Kanya. We have Tororo Municipality, represented by Honorable Apollo Yeri, and I do represent Tororo South. So we don't have him on record. And Honorable Pendi represents the Greater Tororo, which is West Budama and Tororo County. Thank you very much.
Thank you, Honorable. It's not from the record. Checked it.
Madam Speaker, I take that correction of the record. All I was trying to do was to show the shabbiness of the movers in writing in their own memorandum to the committee that Afidra comes from Tororo. But now that the record has been corrected, I will proceed to highlight the report. So the first area of dissent, Madam Speaker, as I said, is that the bill is unconstitutional. The minority observe that the Political Parties and Organizations Amendment Bill 2025 contravenes the provisions of Article 93 of the Constitution of the Republic of Uganda and Rule 130, Sub-Rule 1, Sub-Rule B and C of the Rules of Procedure of Parliament of Uganda. Extracts from the statement of justification of the clauses of the bill signed and presented to the committee by the Honorable Yusuf Mutembuli, MP Bunyole East, in paragraph 2, page 6, is reproduced as follows. The bill in clause 2 proposes to institutionalize IPOD as an organ of the consultative forum. The consultative forum is currently created under section 20 of the Principal Act. The National Consultative Forum shall have two organs. A, the organ, and I underline the word organ, for emphasis, the organ for political parties and political organizations with representation in Parliament, which shall be known as the Inter-Party Organizations for Dialogue. And B, the organ, I highlight again, the organ for political parties and political organizations without representation in Parliament, which shall be known as the Forum for Represented Political Parties, Non-Represented Political Parties, and Political Organizations. This will ensure that political parties represented in Parliament have their own organ within the National Consultative Forum, where they will discuss their unique issues pertaining to them. Likewise, there will also be a forum for non-represented political parties and political organizations in which the non-represented parties also have their own organ to discuss issues pertaining to them. The current council of the National Consultative Forum will remain for the purpose of enforcing the code and dealing with matters arising from the two organs. End of quote. The Honorable Yusuf Mutembuli was accompanied to the committee by Mr. Serwambala Kabagabe Lawrence, who signed his written submission as the Executive Director, Inter-Party Organization for Dialogue, IPOD. Please, Right Honorable Speaker and members, pay attention to the following extracts from the written submission of Mr. Serwambala. Today, open quotation, today, I respectfully submit that it is time to give IPOD the dignity, durability, and legitimacy it deserves by making it a legal entity. I have underlined that word. By making it a legal entity under the laws of Uganda. That is found in paragraph 5 on page 1. He continues, I ask you on behalf of IPOD and on behalf of all political parties represented in Parliament to champion the legal institutionalizing, I underline that point, of IPOD. That is found in paragraph 4, page 2. I also wish to add that institutionalizing IPOD is even more justified by paragraph 5, page 2, as a statutory body, and I underline the word statutory body. IPOD would be empowered to, 1, enforce rules of engagement and ethical codes of conduct among political parties. 2, institutionalize youth and women participation in political dialogue. 3, mandate the regular review of reforms, including those on electoral laws, political finance, and civic education. He continues, such a statutory recognition would also offer structured pathway of emerging political actors to engage with mainstream governance mechanisms, thereby expanding Uganda's democratic base. That is in paragraph 2 on page 4 of Mr. Serwambala's presentation. As a statutory IPOD would be better positioned to, 1, monitor, and members, please pay attention, monitor, evaluate, and report on implementation of agreed up reforms, interface formally with the Electoral Commission, Parliament, and the Executive to track progress, mobilize technical and financial resources with greater autonomy and transparency. Currently, IPOD's operations are donor-funded and dependent on the voluntary participation of political parties. He continues, institutionalizing IPOD will provide it with the legal identity, define government structure, and budgetary allocations from the National Treasury. I will repeat. Provide it with the legal identity, define governance structure, and budgetary allocation from the National Treasury. 2, provide continuity in leadership, programming, and stakeholder engagement. They continue. A statutory foundation would help IPOD transition from a project-based entity to nationally owned and constitutionally anchored institution. That is found in paragraph 2 on page 5. Let IPOD not just be an initiative, but an institution. This is in the concluding paragraph on page 6. End of quotation. It is clear from the written submissions of the movers of the bill and their one-man ally, Mr. Serwambala, that the bill imposes a charge on the consolidated fund. Parliament is stopped from proceeding on any bill or a motion for that bill that imposes a statutory charge on the consolidated fund. This is in Article 93 of the Constitution and Rule 130, Sub-Rule 1 and 2 of the Rules of Procedure. This is the finding of the minority. The minority finds that the Political Parties and Organizations Amendment Bill 2025, privately moved by the Honorable Nakut Faith Loru, Honorable Mutembuli Yusuf, and Honorable Afidra Ronald Olema, violates Article 93 of the Constitution of the Republic of Uganda, and therefore it is unconstitutional. The other dissent is overthrow of the legal mandates of the other institutions. The minority observed that the private members' bill, the Political Parties and Organizations Amendment Bill 2025, intends to overthrow the legal mandates of various institutions conferred by the Constitution and Acts of Parliament. A patient analysis of by the minority observed that Parliament, this institution, Electoral Commission, National Youth Council, National Women's Council, amongst others, will be relegated to be subordinate to IPOD. The mandate to carry out legal reforms is an exclusive preserve of Parliament provided under Article 79. Nobody can make a law to reform issues of elections except this Parliament. 2, the mandate to enforce rules of engagement and conduct amongst political parties is the preserve of the Electoral Commission by law. The mandate to institutionalize women and youth in political spaces is a preserve of the women and national youth councils. The recent policy of the NRM government, as told to us here in this Parliament by the Ministry of Public Service, is that MPAs are being rationalized for efficiency and effectiveness by eliminating duplication and wastefulness. This is my finding. The minority finds that the bill interferes with both the constitutional and statutory mandates of Parliament, Cabinet, Electoral Commission, National Youth Council, National Women's Council, and potentially amends by infection several acts of Parliament which will likely plunge government into conflicts and confusion. It is further found that provisions of the bill appear to contradict the government policy of rationalization, specifically on halting the creations of new bodies, organs, councils, secretariats, etc. The third dissent is on lack of public participation and consultation with political parties. The minority observed that the movers of the Political Parties and Organizations Amendment Bill 2025 did not consult the political parties represented in Parliament and those outside. In fact, the motion seeking leave of Parliament to move a private member's bill was sought and granted to the movers of the bill on the 13th May 2025 around 5 p.m. The order paper listing the bill for the first reading, which was the next day, 14th May 2025, was released on the 14th, just as we are here, on the 13th May 2025, before the bill was even published and gazetted. The bill was published then on the 14th May 2025 and introduced to the House on the same day. The Honorable Chairperson of the Committee of Legal and Parliamentary Affairs scheduled, and indeed the committee held the meetings with the movers on the 15th day of 2025, and today we are here to present the report with only the movers of the bill submitting. It is therefore suspicious that the regulator of the political parties, which is the Electoral Commission, the supervising ministry, Justice and Constitutional Affairs, the political parties represented in Parliament were never consulted by the movers nor the committee. No other stakeholder, including members of Parliament, who had sought, albeit in futility, to move private members' bills on reforms touching political parties and elections, were accorded an opportunity to submit before the committee. The House may recall the vehement submission by the esteemed founding former first son of Uganda, the Honorable Jimmy James Michael Akena Obote, MP Lira City East and party president of the two-time party in government, for those who don't remember, 1962 to 1971 and 1981 to 1985, who is also a member and a former chair of the IPOD. In his submission on record of this House, the Honorable Jimmy James Michael Akena labeled the bill diabolical. The minority found it necessary to recast the dictionary meaning of the word diabolical as below. It means characteristics of a devil, or so evil as to be suggestive of a devil. The second dictionary definition is disgracefully bad and unpleasant. The minority invites the House to pay kind attention and consider the concerns of the party president of UPC, and also recall the concerns of the Honorable Asuman Basalirwa, the party president of JEMA, in as far as implementation of sections 14 of the Political Parties and Organizations Act is concerned. There is no doubt in my mind that the leaders of the political parties in IPOD, who are not members of this House, I have listed them. The Honorable Chagulanyi Robert Sentamo of the official opposition party, NUP. The Honorable Amoriat Patrick Oboy of FDC, One Uganda, One People. The Honorable Norbert Mao of DP, Truth and Justice. And Mr. Magara George William of the PPP, if given the opportunity, would equally have opposed this bill, which has been moved without their views. The minority also observes that the regulator of the political parties, which is the Electoral Commission, with powers to sanction political parties and organizations, has powers to sanction political parties and organizations. The sanctions available to the Electoral Commission includes deregistration, which is an equivalent to a death sentence to a political party and organization. The minority is of the considered view that the Electoral Commission has all the tools, should it be necessary, to deal with any political party which is found culpable. The minority did not receive any single evidence of complaint filed by the movers to the Electoral Commission, and further that the Electoral Commission failed to act on such imaginary violations. This is the finding of the minority. The minority finds that the bill is diabolical. You can recall those definitions, and miserably falls short of meeting the provisions of Article 8A of the Constitution in as far as public participation in enactment of legislation is concerned. It is further found that the speed at which the Political Parties and Organizations Amendment Bill 2025 is being rushed is greatly disconnected with the urgency required and expected of Parliament to solve the contemporary challenges facing Ugandans in the areas of decent jobs, improvement in the healthcare services, provision of quality education, delivery of fair and speedy justice, amongst others. I think I missed. Let me rephrase that. It is further found that the speed at which the Political Parties and Organizations Amendment Bill 2025 is being rushed is greatly disconnected with the urgency required and expected of Parliament to solve the contemporary challenges facing Ugandans in the areas of creations of decent jobs, improvement of healthcare services, provision of quality education, delivery of fair and speedy justice, amongst others. The other dissenting point is the unreasonableness and the irrationality of the bill. The main justification of the bill is stated by the movers to be to condition and obtain commitments, dialogue, and peaceful Thank you, Madam Speaker. The main justification of the bill is stated by the movers to be to condition or obtain commitment of political parties and organizations to principles of tolerance, dialogue, and peaceful coexistence. The justification is shallow, unreasonable, irrational. At registration, all political parties carefully choose their own principles embedded in their constitutions which guide them, and these are registered with the Electoral Commission. In the absence of the express provisions in the constitution of political parties, the recourse is to the national objectives and direct principles of state policies and Articles 29 and 69 to 76 of the Constitution of the Republic of Uganda. Finding, the minority finds that the Political Parties and Organizations Amendment Bill 2025 is frivolous, vexatious, unjustified, unreasonable, irrational, and irrationally false acute, shortly acute, of the constitutional parameters set out in the national objectives and direct principles of the state policy. Conclusion. The minority having found the following. 1. That the provisions of the bill have the effect of imposing a charge on the consolidated fund contrary to Article 93 of the Constitution of the Republic of Uganda. 2. That the bill interferes with both constitutional and statutory mandates of Parliament, Cabinet, Electoral Commission, National Youth Council, National Women Council, and potential amendments by infection, several acts of Parliament. 3. That the bill contradicts the government policy of rationalization on creation of new expenditure centers, such as the 2 organs proposed in this bill. 4. That the bill is diabolical and miserably falls short of meeting the provisions of Article 8A of the Constitution as far as participation in enactment of legislation. 5. The political parties and organizations amendment bill is frivolous, vexatious, unjustified, unreasonable, and irrational. Now, therefore, it is recommended to Parliament as follows: that no question be proposed upon the political parties and organizations bill. 2. Motions seeking leave to introduce private members' bills should be subjected to rigorous scrutiny by way of extensive debates on the justification for the peculiar circumstances to warrant the grant of leave. If I may add, government must first fail reasonably to provide a bill to have a justification for private membership. B. The Minister of Finance, Planning and Economic Development. Be cautioned. The Minister of Finance, Planning and Economic Development be cautioned to execute the mandate of the ministry diligently and avoid late-night escapades of issuance of defective certificates of financial implication. Parliament avoids entangling and entertaining motions and bills arising out of petty quarrels and disagreements between individuals and institutions. Lastly, that the Business Committee of Parliament should convene on more regular basis to conduct business as provided in the rules of procedure. Madam Speaker, before I conclude, when a point of law or a point of procedure is raised in this House, it is my humble prayer that you make a ruling substantially. It cannot, a point of law or a preliminary objection cannot be put to vote. That preserve is entirely for the presiding officer. The ruling must be on the record. You cannot say because the points of law are raised. This is provided in our rules, and I request that where I have raised a point of law touching the Constitution, touching our rules, before you give a formal ruling. It is now hereby reported by this person who signed the minority report. Thank you very much.
Thank you. Thank you, Honorable Doe. The other minority? In the absence of the minority report, Attorney General, we need a response to the issues that are raised, since the government is the one that gave a certificate.
Thank you, Right Honorable Speaker. Right Honorable Speaker and honorable colleagues, I have had the opportunity to read the certificate that was issued by the Ministry of Finance. The plain reading of the same is saying that while there are expenses expected to be used, the money is already in the budget. So what I understood from that there was no imposition. Government had already provided money. This bill is simply reorganizing. It's just simply reorganizing what already exists. So there's a National Consultative Forum for which money has been provided to run the affairs of the National Consultative Forum, and the bill seeks to reorganize the National Consultative Forum.
Does it have an effect on the money that we have always allocated?
No, Right Honorable. That's our understanding, that any other charge. Now, on the issue of rationalization, I again, Right Honorable Speaker and honorable colleagues, the National Consultative Forum consists of all the members of all the political parties registered in Uganda. The iPod that is sought to be introduced, from my understanding, is only relating to a subset of those. All the political parties which are represented in the House are members of the National Consultative Forum. So they are saying we shall have a meeting of the 43 or whatever number you have, but we shall also have another meeting. So I don't think there is anything to do with rationalization here. So I don't know the other issue about the ruling of, I think, Right Honorable Speaker, we may run into a problem if we take the interpretation given by Honorable Odur. We are always discussing matters of law in the House. The principal purpose for which we are here is legislation. And at all points, we are discussing matters of law. So if the Speaker, every time we speak here on a point of law must pass a rule, then I think that's a wrong interpretation. I have not seen that provision in the rules. Right Honorable Speaker, lastly, this is a minority report. There's been a majority report, a minority report, so the members should now be allowed to debate those reports and then make a decision on how to proceed. I beg to submit.
And these reports are basically to form a debate on the next step. So we'll now open the debate on yes.
Madam Speaker, Madam Speaker, I want to draw your attention to this, the wording.
Honorable, just a minute, Honorable Attorney General, the certificate where it says there's a financial implication, maybe you could make a clarification on that.
All right, Honorable, the certificate says it has, this bill has a financial implication which has been provided for in the budget of this institution. Okay. So it is not an imposition of a charge. It is saying that from my reading of this, whatever money you're going to use to do this is already there. So it's not an imposition. They are not imposing a charge on the they're actually just spending what has been provided.
Okay.
Madam Speaker, the records of my submissions are already with you, but I want to remind you on this, that before we go to debate, you resolve this matter. Rules regarding settlement of financial matters. A question shall not be proposed upon a bill, motion, an amendment bill, or amendment to a motion which has not been introduced or moved by a minister. If, in the opinion of the Speaker, the object of the bill, motion, an amendment bill, or amendment to the motion is to make provision for the following: A, the imposition of taxation or alteration of taxation, otherwise by reduction, not applicable to this. B, the imposition of a charge upon consolidated fund or other public fund of Uganda, or the alteration of any such otherwise by reduction. And C, the payment issue, etc. The point I'm making is that your opinion as the Speaker let me finish. Your opinion as the Speaker is first required. If the Speaker rules the presiding officer, because these records may form part of other proceedings, so you cannot, as the Speaker, just wish it away. If, in your opinion, what is your opinion on this point?
This certificate, Honorable Dur, this certificate was given by government. And the certificate that was given by government, I have asked the government to respond to the issue whether it imposes a tax or it has an effect on Article 93. And government says it does not have an effect on Article 93. And if government says it does not have, and that is the legal advisor of government, and says it has no effect, then it doesn't. Is a legal advisor, yes, finance?
Right Honorable Speaker, through my minister, I wish to state that the certificate of financial implications which we issued does not create additional financing requirements by government. We have been providing for a budget for political parties. This exists in the budget which we are running now and the budget which we passed on Thursday. What this law is requiring is conditioning access of this money to certain rules and standards. Otherwise, the money which we have been providing will remain the same. And this is why we said this certificate will not impose new financing requirements. It will be financed within the already provided for budget.
So it has no existing imposition of levy on 93.
Madam and honorable members, you will bear with me. If you listen carefully to the submission of the minister, he does not deny a charge on the consolidated fund. All he's saying is that there will not be an additional. The wording of the Constitution and the rules does not include the word additional. It just says a charge.
Honorable Dur, we have been providing for money for political parties in this house. And in provision of that money goes to political parties in the house. And that money goes to political parties. What the law is now saying, we have parties in the house that do not subscribe to iPod. Now, those parties that are in the house must first subscribe to iPod for them to be able to get what? To get part of this money. There is no additional money that is being added on political parties. It is exactly the same amount that has been there that is going to be distributed according to the numerical strength in the house. But the law is also saying, if you do not operate by being part of iPod, then you do not qualify. Meaning that if you don't participate in iPod, the money that is going to be distributed to the other parties that are in the iPod actually will be within them and it increases on their money. Yes, Dr. Chris. Let's first have Chris.
Thank you very much, Right Honorable Speaker. I think the Honorable Dur should not mislead the House. What Article 93 refers to is for a private member's bill to introduce additional burden, a charge or a tax, which is not applicable in this case. There is no new charge or tax being introduced by the bill. And therefore, I think, and he knows it, but he's just taking Parliament for a ride. So I just invite you to cease fire and let the House debate these reports.
Akamba. Honorable Akamba, Honorable Ole.
Thank you, Tony. Right Honorable. Right Honorable, the Article 93 of the Constitution is very clear, and it does not, the current bill does not in any way offend the article. Because, Right Honorable Speaker, I read the article verbatim. It says, in summary, it prohibits Parliament from proceeding on a bill or an amendment unless it is done on behalf of government which imposes a charge on any public fund. Right Honorable Speaker, the Political Parties Act, which is already in existence, created a charge on the public fund, and that's not in doubt. All what the bill is saying is how should this money be spent. It does not in any way suggest, there is no single provision that says or proposes that there will be another charge made on the consolidated fund. So in my opinion, the bill is constitutional and it does not offend that Article 93 in any way.
Thank you. Let Odur wind up and...
Thank you, Madam Speaker. This is my last, and then it can be debated. I'm submitting that without prejudice to the issues debated by the Right Honourable Speaker, I request that as per the rules, you give your ruling so that the House can proceed. I have given my ruling that it does not have an effect on the consolidated fund, Article 93, as already stated by the legal advice of government and stated by the Minister of Finance. Honourable members, physically we have 148 members, and then virtually we have 49 members. That takes us to 197. Yes. Honorable Hati.
Madam Speaker, we want to thank the committee, but also to appreciate the issues raised by the minority report, and we have had clarification that actually this bill has no imposition of extra charges. We have also, from the report of the committee, the majority committee, heard that the bill is not diabolic. It's actually intended to organize the current situation of political parties. And having listened to both sides, Madam Speaker, I wanted to move that this House can move to another stage so that we proceed with the bill. I beg to move.
Seconded. Seconded by Barbie, Koeda, Nalukoola. By the whole House, with the exception of Odur. I put a question that the political parties Organizations Amendment Bill 2025 be read. Second time, those in favor say on the contrary, nay. The ayes have it.
The Political Parties and Organizations Amendment Bill 2025, Bills Committee stage. Clause 1.
Procedure.
Chair.
Procedure, Honourable Speaker.
Yes.
As a member of the iPod Summit, I am finding it extremely strange that I cannot even put input on the goings on of iPod on record. You see, Madam Speaker, every parliament we have debated a memorandum, and there's a current memorandum which is standing for iPod. And the chair of iPod for the last 4 years has been NRM. And if there's any breach, it is NRM who have failed to call a summit or even a council meeting. So it is important that we deal with this actual issue, because what are we correcting? What is the sickness? What is the disease we're correcting? At the moment, the summit has not sat since NRM has been in the chair for 4 years. Yet it's supposed to be 6 months. The provisions which are being brought now are being brought in bad faith
because in the last parliament, under the chairmanship of Honorable Boss of Boss, IPOD brought it and I personally presented them to the same committee. Because the increased funding which came in a supplementary of 2020 had IPOD in it. And how was that money to be shared? At that time, political parties were sharing 10 billion per annum. Under the IPOD arrangement, it was increased to 35 with $5 billion going as the 15%, another $5 billion for covering the other 15%, and then 70%, the 25 billion, was on numerical strength. At that time, the president acknowledged that NRM acted in bad faith by not allowing that amendment to pass. They acted in bad faith. The words of the president, unchristian. And now we are going through a process to undermine everything. There's no dialogue here. If we talk about dialogue as a political party, as a leader of a political party, as the political party which first held the first summit from 2009, the first summit was held in December 2018 under my chairmanship. And the principle which we're debating is what we agreed in that. It's under the democratic permit. As a political party, we have not been consulted. How is it that we're debating this issue? And that is why I say it is diabolical. It is not done in the interest of the political party. I speak for UPC. My brother is not part of this. And I'm thankful that Mao is not here to embarrass himself. This is wrong. And we shall all be judged.
Thank you.
Let us be honest.
As I thought, the member raised her issue. You still have a gap as members of IPOD to go and ensure that you discuss this issue and maybe ask the president not to assent. Close one.
Close one.
Close one.
Madam Chair, the committee proposes an amendment to clause 1 of the bill in the following terms. Clause 1 of the bill is amended by substituting for the proposed subsection 2 the following.
that the House do resume and the Committee of the Whole House reports thereto.
I put a question that the House resumes and the Committee of the Whole House reports thereto. Those in favor say the contrary, nay. The ayes have it.
Honourable Speaker, the Committee of the Whole House has considered the bill entitled the Political Parties and Organizations Amendment Bill 2025 and passed it with amendment to clause number 1.
Motion for adoption of the report of the Committee of the Whole.
Honourable Speaker, I move that the House adopts the report of the Committee of the Whole House.
I put a question on the report of the Committee of the Whole House in this House. Those in favor say the
Bill start reading. The Political Parties and Organizations Amendment Bill 2020.
Yes.
Thank you, Madam Speaker. Madam Speaker, I would like to raise, I think it's actually the Constitution and our rules of government. I can confirm the number of members present. I request that you put on record the number of people attending online so that we can confirm as 40 mentioned.
Honourable, although I mentioned it, I don't know what you thought about it. I did it, I mentioned it, and I still maintain what I mentioned. Honourable,
Honourable Speaker and honourable members, I move that the motion that the bill entitled the Political Parties and Organizations Amendment Bill 2025 be read the third time and be passed.
I put a question that the political parties and organizations amendment bill 2025 be read the third time and be passed. Those in favor say the contrary.
The bill for advance title of the Political Parties and Organizations Amendment Act 2025.
Time was settled and the bill passed.
Item 5 on the other paper. Bill second reading. The Uganda People's Defense Forces Amendment Bill 2025.
Honourable members, we call on Tuesday, 2025, the Minister of Defense and Veteran Affairs tabled the bill, the Uganda People's Defense Forces Bill 2025 for the first reading. The bill was read for the first time by the Great Committee of Defense and Internal Affairs and the Committee of Legal and Governmental Affairs pursuant to Rule 200, the Rules of Procedure. The Joint Committee is now ready to report, and pursuant to Rule 136(1) of the Rules of Procedure, I will invite the Chair of Defense and Veteran Affairs to move the motion to that Defense and Minister of Defense and Veteran Affairs to move the motion to that effect.
Right, Honourable Speaker, I beg to move that the bill entitled Uganda Defense Forces Amendment Bill 2025 be read for the second time.
Seconded by Honourable Barbie, Honourable the Vice President, Honourable Kasuku, the Prime Minister, Honourable Amandement, the Honourable the Vice Deputy PM, Prime Minister, Honourable Honourable Affairs, Honourable Police, Honourable Jay, Honourable Maliango, Honourable Mifa, Honourable Misasisi, Honourable Barbie, Honourable Kenzo, Honourable the youth MP. Great. Honorable Minister Mosi, Honorable Finance, Honorable Kasaidia, Shani, Honorable Council, Honorable Government Chief Whip, by the Honorable Yes. Would you speak to your motion?
Honorable Speaker and colleagues, the record of this House has it that this bill is also intended to rectify, to remedy the existing defects in the law. The last time this Parliament handled this bill was 2005, and the Uganda Defense Forces Act 2005 was enacted in 2005 to provide for the regulation of the Uganda Defense Forces in accordance with Article 210 of the Constitution. It's a repeal.
Honorable, I meant Honorable Mayor is not the host, so here is not the host. And I want to go that way.
It is a bill that reflects the armed forces. The Armed Forces Pensions Act